Starting the record button now. All right, so now we're recording. I'm just waiting for it to upload to Facebook. Right, Facebook. Sorry.
Yeah, we got to get you guys the Facebook views.
All right, so we're live, guys.
Hello, everybody. Welcome, welcome, welcome. This is the third iteration of our virtual town hall series with the Virginia COVID-19 Justice Coalition. We are very, very excited for tonight's meeting. We are super lucky to have with us several Commonwealth attorneys from across the state. And I will be introducing our wonderful moderator for tonight, Mr. Brian Kennedy, who is the Policy Director with Justice Forward Virginia, an organization that works for criminal legal system reform in our state. And he is also a Senior Assistant Public Defender in Fairfax. So take it away, Brian.
Great. Thanks very much, Johanna. I'm going to start by introducing our panel. We have four elected Commonwealth's attorneys. So they are the chief, well, three of them are the chief prosecutors in their jurisdiction, and one is basically a manager assistant in his jurisdiction. So I'll introduce each of them, then we'll get our conversation started. So first we have Buddha Bibaraj. Buddha was born in Montenegro, and she was raised in the Bronx in New York City. She received her JD from George Mason School of Law in 1993 and opened up her practice in Leesburg in Loudoun County shortly after that. She was a defense attorney for over 25 years, and she was a substitute judge in Loudoun for over 11 of those years. And she's a longstanding member of the Loudoun County Bar Association. Just this past year in 2019, she was elected as the Commonwealth's attorney for Loudoun County. And as Commonwealth's attorney, she's been committed to make sure justice is delivered to all members of the Loudoun community and that our office manages resources wisely and accountable to the community. Next, we have Parissa Dagani-Tafti. She is the Commonwealth's attorney for Arlington County and the city of Falls Church. She was elected in the past November as well in 2019. She comes to the office of the Commonwealth's attorney with a 20-year record of criminal justice reform as an innocence protection attorney, a public defender, and a law professor. In her prior life as an innocence protection attorney, Parissa served as the legal director for the Mid-Atlantic Innocence Project, where she successfully helped exonerate innocent individuals in DC, Virginia, and Maryland incarcerated for crimes they did not commit. She litigated at all levels of state and federal court, including the U.S. Supreme Court and the Supreme Court of Virginia. She was also a public defender with the Public Defender Service in the District of Columbia, where she won the first DNA exoneration case in DC. She has also been a law professor at Georgetown University Law Center and George Washington University School of Law. Ramin Fatai is a deputy Commonwealth's attorney in the city of Norfolk, where he supervises a prosecution team responsible for cases involving drug distribution and possession, impaired driving, and vehicle fatalities, among other things. He's also the chair of that office's Criminal Justice Reform Working Group, which drafts procedures to implement criminal justice reform priorities of the chief Commonwealth's attorney there in Norfolk, Greg Underwood. Ramin has served as a prosecutor for 13 years and has specialized in homicide and violent crimes, drug crimes, financial and property crimes over the course of his career. He had previously also worked as a multi-jurisdictional insurance fraud prosecutor, an assistant Commonwealth's attorney in the city of Norfolk, a special assistant United States attorney in the Western District of Virginia, an assistant Commonwealth's attorney in Chesapeake, and an assistant public defender in the city of Richmond. He was also a law clerk for Justice Lacey of the Supreme Court of Virginia. Finally, last but definitely not least, Shannon Taylor is the Commonwealth's attorney for Henrico County. She was first elected there in 2011, which surprisingly and unsurprisingly made her the first woman to hold that position in the very long history of Henrico County. She was elected again in 2015 and again this past November in 2019. Shannon's a native of Charlottesville. She received her law degree in 1995 from the T.C. Williams School of Law at the University of Richmond. She started her career as a prosecutor at the Commonwealth's Attorney's Office in the city of Richmond, and she was a special assistant United States attorney in 1999, as well as again in 2002 to 2004. She was also special counsel for the Richmond Multi-Jurisdictional Grand Jury, where she worked closely with the Virginia State Police, the ABC Board, and the Virginia Department of Taxation. So obviously a very well-accomplished in lots of respects panel, and a lot of diversity, both in time of being prosecutors and in location across the Commonwealth. And the first thing we want to do for everyone watching is make sure that everyone understands what the role of the Commonwealth's attorney is in a jurisdiction. Most of you have received, and if not, you will receive a helpful printout from the ACLU that summarizes that. But we want to give each of the Commonwealth's attorneys here about 2.5 minutes to tell you about their job and what they see their role in the criminal legal system is. So I'm going to go from what's my left to my right, and I'm sure you'll all build off each other as you go, but basically just tell us, for someone who doesn't know, what is the role, what is the job of especially the Chief Commonwealth's Attorney? And Parissa, you are up first.
Want to make sure I unmuted myself, or unmuted myself. Good evening, everyone. Thank you for having me. So I talk a lot about sort of 4 roles of the Commonwealth's Attorney. And I mean, I think everybody brings their own spin onto it, but I think about it in terms of priorities, like setting priorities and policies. So, you know, what cases are we going to focus on to prosecute, obviously? What are our policies in terms of, you know, making sure that defendants have their due process rights, making sure that we protect victims, and you know, assess what we need to do sort of on a day-to-day basis in order to protect the community. The second sort of, I guess, bucket of responsibilities is community engagement, and it's doing things like this, but also, you know, having town halls, being out in the community to do both listening, but also public education and community partnerships. The third role is an advocacy role, and you know, that is lobbying for legislation that we think we need, either to give us the tools to prosecute, or, you know, some of what we're doing now, which is, you know, legislation to protect defendants' rights. I know that you know, Ramin supported, and so did Shannon and Buta. We all supported certain legislation that would have given judges the ability to defer disposition, to, you know, create deferred dispositions. They would have given judges the ability to sentence defendants. So, you know, a lot of us spent a lot of time in Richmond this year working help us do our jobs and help us really sort of bring forth this decarceral, a more decarceral criminal legal system. And finally, there's, you know, the office management piece, and that's, you know, simply like being a leader and, you know, support, you know, creating like trainings for staff, and, you know, an environment where staff can really participate and grow. And those are sort of the 4 areas, and I'm sure that others will say things probably more eloquently than I did, so I will pass it on to them.
Great, thank you. Shannon.
Sorry, not graceful with the thing right there. Well, first of all, Brian, thank you for that great introduction. Although I will say the one thing that was missing is the fact that I was a criminal defense attorney for 3.5 years, and that's what I was doing in 2011 when I was approached to run. And I think that's really important, because I think the idea of having a balanced perspective is critical, and I believe makes our jobs as prosecutors much more successful. I love what Parissa just said. I would add to that what we are not is we are not the lawyers for the police department. There's been a lot of talk of that lately, and this group on this call, I think, would really appreciate the fact that we, for those of us who are on this panel, we know what we're about, and we are not the lawyers for the police. But Parissa hit the nail on the head, because I've been echoing that same statement, that it is about protecting the victims who have been violated, either personally or the property rights have been violated. But we also are the guardians of that Constitution, and particularly. We'll probably talk about this more. For those who do not know, Henrico County does not have a public defender's office. And so this idea of trying to make sure that we have just as much of a responsibility as court-appointed counsel who may not have the time to do what they're doing because of what's happening in Henrico, it's our job to do that as well and work with the bar council to make sure the Constitution is being heard. And Peter says, Brian, can you hear me okay? I'm done, but I just want to make sure you can hear me.
I can hear you better now as you're closer to the mic.
I just pulled closer, sorry.
No problem. And Ramin.
All right, thank you, Brian. I'm an exalted company here. I'm really pleased to see my friends from across Virginia. I am going to speak for the Commonwealth's Attorney of Norfolk, for Greg. And I will agree wholeheartedly with what Shannon and Parisov both said. The primary goal of a Commonwealth's Attorney is to keep the citizens of his community safe. Now, the classic definition of that in the bad old days of the war on crime and the war on drugs was hem everybody in, arrest everybody, prosecute them, and get a maximum sentence. We've now learned that is, in a lot of ways, precisely the wrong way to keep our citizens safe. And what you're seeing in forward-thinking, evidence-based, and science-based prosecutors, like the prosecutors before you here, is that we keep our citizens safe not by prosecuting everything to the maximum extent possible, but identifying the small number of people who are truly violent and dangerous, the people who are taking the lives or seriously harming the people in our communities, and separating them from the people whose criminal behavior is a symptom of a larger problem, be it substance use disorder, be it mental illness, and finding a way to treat those individuals with compassion and with mercy, and finding a way to keep them from what in the bad old days would have been simply cycling in and out. We are policy advocates. We are very much administrators. I can tell you that our office has over 90 employees, 40 lawyers, and over 50 staff. So there's a lot of budget advocacy to make sure that we have adequate staff to handle our cases properly. Very much policy advocacy and policy setting. Absolutely, Shannon's right. We don't work for the police and they don't work for us. But I would also say that there are 120 prosecutors, and they go from offices like Virginia Beach, bigger than us, to offices where it's a single part-time Commonwealth's attorney who does it all. So the role of a Commonwealth's attorney, for those of you who are out there watching, very, very much depends on whether you live in a big or a small jurisdiction.
Thank you, Ramin. And Buddha.
Thank you, Brian. And it's nice to see everybody. I don't know what the heck is left that I could add, but being a lawyer, I will add. So what we want to be able to do is we do want to focus on how we do our jobs, and that is by basing it on evidence-based prosecutions and policies. The biggest thing that we do in our office is really have what we call guiding principles, and the main thread is balancing the harm. And that being, what is the harm that we are going to impose upon the accused, and that it should be consistent with, but not exceed the harm that was to the community. So although somebody may have an offense, there's an offense that somebody committed, if it's a low impact to the community, then we shouldn't be locking them up for long periods of time, because we are also stewards of the community's resources. And that includes obviously the money, as well as the human factor. And the human factor is going to be the person who's accused, the victim, and then all of those layers that come around or stem from there. So that what we need to do is we are protecting the entirety of the community. We've talked about this in our office, where if and when this job is done right, it is the toughest job in the whole process, because we are literally protecting everyone's interests, the victims, officers, the accused, the courts, the community. I mean, there's not any person that we don't take into consideration when we're making the decisions. So this is a very tough job. But if you have the right people in office, like I think the individuals who are on these screens are, then we are going to be able to do it the right way. Thank you.
Thank you very much. So for everyone listening, what basically we're going to do for the rest of the time, at least before we get to our questions and answers, and I should say, if you do have questions, either on Facebook or on the Zoom, please put them in the chat, and those will get to me towards the end of our program, and we'll have people ask those. But what we want to basically do is focus on COVID. So I want everyone to remember, and I'm going to hold everyone, both the panelists and people asking questions to this, that there's a lot going on in our country right now that we need to discuss in this area, but we want to keep a focus on COVID and that its impact, especially on people in the criminal legal system, whether it's people who are out, people who are in jail, or people who are in prison. And what we want to do is work with the panel here to try to come up with things you can do no matter where you live, whether it's in a small county with that one part-time Commonwealth's attorney, or in a lot of these counties, which are medium to big size counties with a big staff, where you can reach out to your Commonwealth's attorney, whether it's one of the four of the people on the panel or someone else, and advocate for people in your community and advocate for better treatment of people. So what we're going to start with, and I think we have enough time for 3 minutes per person if everyone wants it, up to 3 minutes. I'd like each of you, and we're going to go in reverse order back from what we just did, to tell us what has your office done since either mid-March or maybe before, depending what you were doing, to help your jurisdiction get through the pandemic and to help especially all people, whoever it is, you all talked about a lot of different groups your office serves, help all people that you represent to get through the pandemic safely. So Buddha, we'll start with you.
Thanks, Brian. I think the first thing that our office did is we reallocated resources. We knew and were hopeful that it wouldn't happen, but we predicted that our cases involving domestic violence would have an uptick. So what we ended up doing is we reallocated an additional attorney as well as an additional staff member to the special victims unit that we have in our office so that they could handle the bulk of those cases. When the court shut down, a lot of the other courts, the General District Court and Circuit Court, those cases with appearing before the court decreased in number, but our juvenile and domestic relations cases with the domestic violence did not necessarily decrease in frequency. And we had cases that were in a pipeline, so we needed to be able to provide some sort of resolution for those families that were in crisis. So we added those resources to be able to handle those cases, and our juvenile court did a superb job in trying to manage as many cases as people were willing to allow to be going through the court system, to go through the court system. The other thing that we ended up doing during the COVID aspect is we addressed our incarcerated individuals. In our local jail, we have approximately 400 to 425 on a regular basis, due through normal attrition, people serving their sentences, as well as us trying to downsize on the Workforce Work Release Center, as well as those who had less than 6 month sentences remaining, and then those who were appropriate for release on GPS and other secured systems. We were able to reduce that. Right now, we are probably at about 220 individuals who are in our jail. So that's been the biggest, I think, contribution to the community, is making sure that we are not having a festering of this captured audience being at risk for COVID and spreading that in our community.
And Buddha, let me ask you a follow-up. In terms of people serving sentences and people doing, you mentioned people with fewer than 6 months left on their sentence you looked at. How did that process work? What was your involvement compared to other actors in the system, and what was your success in people you thought should get out in terms of actually going to court and getting them out?
It was an interesting process because the governor has sent out a recommendation saying, to the different localities, please look into this. Initially, our courts didn't want to take any part of it. And I don't know if this is the fear factor that nobody wants to have their name on a piece of paper that might allow somebody to be released, and God forbid they go out and they reoffend. So that fear factor really is very limiting, and we have to change that culture within our judiciary. But I was actually contacted by our jail, and they said, we want to close down our work police center, which only had about a dozen individuals in it, because we were expecting that with COVID, we might actually need that facility. So although there were only 12 people there, it was a pretty significant size facility that might allow for some overflow to be able to segregate individuals that may need to have to be separated from the others. So they contacted us, and we started working with the defense attorneys to put in consent orders. Some of them were approved by some judges, some were denied. So it really was going through the process. And then what we also tried to do was to articulate, in addition to the COVID concern, why this was appropriate. The jail helped us, as well as our ability to access records, helped us to try to screen those individuals who we deemed were not a safety risk. For workforce, work release, that was kind of easy because they were already going in the community. So that was not like the threat factor. And then we just tried to look at others who had the less than 6 month sentences.
Great, thank you. Ramin, can you tell us a little bit about what you all did in Norfolk?
Yes, I'd be glad to. So I think I mentioned that our sort of core purpose as prosecutors and as Commonwealth's attorneys is colloquially to keep people alive, and that is our job. And in the COVID crisis, that the focus really, really became on keeping people alive who were in custody, so decarceration. To give you an idea of some of our numbers, on February the 1st, the Norfolk City Jail held 904 individuals, pre-trial and people who were serving short sentences. As of July the 1st, we have 610 people. So we dropped, we couldn't cut by half. Buda, that's absolutely amazing that you cut by half. We cut by about a third. And that was sort of an all of the above method. Fortunately, we had judges who understood the severity of this emergency and were very cooperative. We had a very forward-thinking sheriff, which is also an elected position, who was extremely forward-thinking, and we all worked together. So there was an increase in sentence credits, the amount of good time that people got. That was a piece. There was cooperation between the sheriff and the magistrates for misdemeanor cases, which we do not prosecute. Thankfully, we're not funded to do it. That was a piece. The really the two biggest pieces from our office were, we started getting involved at the arraignment stage of cases, the initial appearance before a defendant was even appointed a lawyer. And we were looking at the arrest information, including the summary sheet of the magistrate official who would examine people and give us a summary of criminal history. And rather than waiting for the person to be appointed counsel, to set a bail hearing, to make a decision, we had senior prosecutors there every morning in court, looking and releasing people on recognizance bonds with the court's acceptance. And that provided a huge cut. We also, I think practically without exception, as the sheriff or the courts or defense counsel brought us requests for home electronic monitoring or other incarceration alternatives, we agreed to it. And frankly, one of the things that we did is we changed the way we thought about who should be held without bail. In Virginia, the two tests are whether the people are a danger to the community, meaning really the others or themselves, or whether they have a risk of not coming to court. And we made the calculated decision that we were going to focus exclusively on danger to the community. That the only reason that we were going to have somebody held in the Norfolk City Jail with the risk of a COVID outbreak, and we had a COVID outbreak. We had 49 positive inmates at one point. The sheriff miraculously has driven that to 0, but was able to do that because of segregation abilities with the extra capacity. But we basically looked at if we were dealing with a non-victim crime and a non-violent crime, because a violent crime, inherently, there's a danger to the community in the charge. If we were looking at a non-violent crime with no victim, even if the person was a terrible risk for reappearing, we were agreeing to bail. We agreed to bail because we felt that our paramount duty was to make sure that nobody got sick in the jail who didn't need to be in the jail. And we've had very good success with that.
Great, thank you. Shannon, can you tell us a little bit about Henrico?
Sure. I know that often this group talks about prosecutors being the most powerful person in the courtroom, and I do agree with that, except for when we're talking about this issue. And Henrico Historically, our judges have been not as, I'm going to use the word flexible, as others when I've been making my pitches for change. So I want to break this down into three things. Because first and foremost, let me say, nothing like a pandemic to bring everybody together, because I've never seen the judges working so hard.
I'm having a hard time hearing you.
I'm sorry. I was why the volume's not so good. So I apologize for that.
Like right now I can hear you perfectly. So
maybe I'll have my face like right in the computer.
But you're saying some really important stuff and I don't want people to miss it.
Okay, sorry about that. Gosh, I'm on the work computer anyway. But so just I'll may start that over again if you'll give me a little extra time. I made the joke about like nothing like a pandemic to bring everybody together, but it's really true because our judges historically have not been most open to certain changes or as flexible as some of my colleagues in the other jurisdictions. But really, I am going to say hats off. I feel like in Henrico, we've had a good teamwork approach. And I also want to give a huge kudos and shout out to my new sheriff in Henrico County, Lisa Gregory, because I didn't have to work as hard as Ramin was just talking about, because right from the beginning, if anybody knew anything about my election in Henrico, we talked about an overpopulation in the jail. So I was already, as soon as Lisa Gregory won the election in November, she hit it on running. We were already working about, reducing the population in Henrico County Jail. And that cooperation just continued. And then we were dealing with the pandemic. And we actually would get the list from the sheriff's office. So they were the good ones identifying the vulnerable populations regarding age, pregnant women, people with other health care issues. They were the ones who were able to identify how much time is left on someone's sentence. Could they go home to, serve the remainder of the sentence? And we had judges who were trusting those judgment calls. So to date, I can tell you we are down. We were probably at 1,600 before November 2019. We're down to 1,154 and have diverted 724 people. And that's diverted. I mean, finished their sentence and they've left, but actually been diverted. So that was the good news, kind of like working on the back end. On the front end, we had worked with police about police issuing more summonses, putting any dates out far enough so that people weren't coming to court. And it was really important to make sure that courts were still operating. We were closed on Monday of, I think it was March 16th, to do a big cleaning. But other than that, Henrico County courts have been moving forward. It may not be all 5 circuit courts or all 5 general district courts, but there was always a court running. And I continue to have the judges understand that we needed them to think outside the box, to not read everything so literal within the Supreme Court order, but if we could come up with resolutions to advance effort on the docket and get people out of jail. So we were able to work out that way. And we're still working in that capacity. And as we all know, the next big question is about your trials, because the balancing act of, like I hear from Jim, I might close out and come back and see if that helps. But my last comment is that it is a very, very delicate balancing act between making sure that your employees' health is paramount, the other people in the courthouse is paramount, but also defendants have constitutional rights, which we have to protect and make sure the system is going.
Great, thank you. And Shannon, Jenny also put in there about calling in, so you could mute your audio on the video and call in.
I'm gonna try to jump back in and let me see what happens.
Yep. So Parissa, can you tell us about Arlington County?
Yeah, so I came in with the intent of reducing the jail population, and immediately we stopped asking for cash bail in any situation, and focusing, as Ramin said, on dangerousness and what is a true flight risk, not whether somebody may not show up because they forget or they can't get there, but true flight risks. And when we saw COVID sort of approaching, it was the third week in February that I really sort of realized that this was going to be a really, really bad situation. And I'll say this for partnerships, because nothing would get done if it hadn't been for, our partnering up with the public defender and with the sheriff's department, to really share information and to work together, and the defense part to work together to identify who could be released. And we reduced our jail population by a third in 1 month. And I started getting printouts from the sheriff's department on like every other day at one point, and just going through, if somebody, like identifying everybody who had a bond amount from, the previous administration, or somebody who got a secure bond set over our objection, and just identifying everybody who was under 15,000, and literally calling up the defense attorneys and saying, file a motion for reconsideration of bond, we will agree to release. And we just really did that in a systemic and aggressive way. The sheriff, having the sheriff and the magistrates and even the police on the same page about issuing summonses rather than arresting people, releasing people on conditions rather than holding people, really helped. And we also started looking at the back end, cases, the people who were serving time. And so anybody who was serving, who had 6 months left, like Bita did, we were, the public defender had filed in a lot of cases, and we looked at those cases and were agreeing to release in a lot of them. We also looked at cases for people in the DOC and started, sent letters to the parole board and the Secretary of the Commonwealth saying, here are the people that we think you should release. For the people who the court no longer had jurisdiction over. And I did the same thing with the juvenile court right away in early March. I got a list, and we started figuring out exactly with our court services unit, which of the kids we could send home. And we were only able to send about 20% of them home, but right now our juvenile population is down to 6. And our jail population is 206, which is the lowest anybody remembers it.
That's great. So the next part of our conversation is going to be going through the coalition demands, which I know we sent all of you, and it's basically a brainstorm. So what can Commonwealth attorneys, and it sounds like in a lot of ways you all have done work that would further our demands, how can a Commonwealth attorney, whether it's you or your colleagues across the state, help to continue these efforts? And Shannon's not back yet, but in the effort of keeping moving things on, I have a few questions that I want all of you to answer. So if you unmute all of you right now, and basically I'm going to ask a question and it's a yes, no, and I'll just go Parissa, Buddha, Ramin. So yes or no, they're not too crazy. So say yes or no, and we'll get back to exceptions after that. So do you all agree that COVID-19 is a threat to our communities until we have a vaccine or a reliable treatment? Parissa?
Yes.
Yes.
And Ramin?
Yes.
Do you all agree that people in jails and prisons remain particularly vulnerable to COVID-19 until we have a vaccine or treatment? Parissa?
Yes.
Buddha?
Yes.
Yes.
And Ramin?
Yes.
And do you all agree that reducing jail populations and prison populations is an important way to limit the spread of COVID-19? Parissa?
Yes.
Buddha?
Yes.
And Ramin?
Yes.
Do you all agree that a Commonwealth attorney has the power to help reduce jail and prison populations? Parissa?
Yes.
Buddha?
Yes.
And Ramin?
Yes.
And do you all agree?
It's way too easy.
I know. Well, I wish it were easy across the country, because I'm not sure if we asked everyone in Virginia or across the country these things that everyone would agree. But it's really basically helpful to make sure we're all on the same page about this before we start the conversation. So our first coalition demand is that people are released from custody, and that's both jail and prison and other civil detention across the Commonwealth, if they do not pose a demonstrable imminent threat of bodily harm to someone else. So the first thing I want to ask you all about is, each of you mentioned protecting victims. Each of you mentioned community safety, risk to the community in terms of bail. I saw Shannon jump on here, so we'll wait for her for a second.
Hey, Brian, I know that time is really limited. If we have a few seconds here or there, there's I think a really important point about basically the self-sacrifice that is going into these decarcerations in terms of what's happening to sheriffs and their staff. I don't want to hijack the conversation, but there are major implications to what all of us are doing in the interest of public safety.
Sure, I will write that down and we can come back to that later. I think there's going to be some time for that. So Shannon, I'm going to put you on the spot for what you missed, and we'll see how.
I'm back. Can you hear me? Can you hear me better?
I can hear you better. So
Okay.
I just asked everyone some questions, and no pressure, but everyone else said yes to all of these questions. So the first question
Thank you for giving me the answer already.
yeah, well, if you disagree, it's important. So we just want to let you know. Do you agree that COVID-19 is a threat to our communities until we have a vaccine or reliable treatment?
Yes.
Do you agree that people in prisons and jails remain particularly vulnerable to COVID-19 until we have a vaccine or reliable treatment?
Yes.
Do you agree that reducing jail and prison populations is an important way to limit the spread of COVID-19?
Yes.
And do you agree that the Commonwealth's attorney has power to help reduce jail and prison populations?
I think we've all just demonstrated that. So yes.
Again, I wish everyone in the country believed that. So what I was going to say is you all mentioned that community safety is important to you, and our demand includes releasing everyone who does not pose a demonstrable imminent threat of bodily harm. So I'd like each of you to comment on whether you have, it may come in the form of a policy that you have, a formal policy in your office, or how you conceptualize danger to the community. And what I want to know is someone charged with murder who you think you have a great case against, fine, let's put that aside for a second. Someone charged with larceny offenses who has a unlawful wounding on their record from 5 years ago and a malicious wounding on their record from 10 years ago, where is that continuum? Where does that person fit? And how do you figure that out? So I will go with Ramin first.
So the fundamental test for us and whether somebody is a danger to the community is one of two things. Is the charge that is before the court or a charge that is currently pending in another jurisdiction a violent offense? So someone charged with malicious wounding, for example, which is essentially a failed murder. That's what malicious wounding is. Well,
I want to push back on you there for 1 second. Malicious wounding in Virginia is also punching someone in the face and breaking their nose.
Correct. But that's why we don't mechanically apply it.
Okay.
But I'm distinguishing something like a malicious wounding from something like a larceny, where there's no colorable way that the charge itself is demonstrating a danger to the community.
So let me ask you the hard question then.
Sure.
If someone is charged with malicious wounding, and I'm coming to everyone on this question afterwards. So if someone's charged with malicious wounding and it's not a firearm and it's not a knife, it's shod foot, it's hand, it's a fight and not a mob assault, person on person bar fight, do you consider that person to be, that's all you know about the person, do you consider that person to be a risk to other people, a risk of public safety?
In a vacuum, it's hard to say. I think that obviously all the factors you ruled out would make it an easy question. I think it would have to depend on the severity of the assault. You know, if it's a punch to the nose that broke the person's nose, I think that it's hard to say in a vacuum that demonstrates an immediate threat to other people or to himself. Now, if it's a hands and feet beating to within an inch of the victim's life, or the victim is in the ICU, you can hurt people worse with your hands and feet than you can with a weapon. So, in a vacuum, I can't say yes or no. It is going to be fact dependent. But I think that those are the cases where we do look at the facts, and if it appears to be a completely legitimate charge, a victim in the ICU, the answer is probably going to be probably not. But the prior record will come into play. If it's simply a single punch, as you've described it, and you're right, the appellate courts have ruled that can be malicious wounding. Then we look at the whole person, and if it appears to be an out of character incident, then I don't think that we meet the standard that the person is a danger to himself or others, an imminent one.
Great. Shannon, can you tell me, you were nodding through a lot of that. Tell me your thoughts.
Oh, no, because I'm thinking about a case that we had that happened right before COVID kind of exploded. And it was a woman who bludgeoned, a gentleman who bludgeoned a woman within an inch of her life. And he attacked actually two women and then left the state. But he's being held without bail because of the severity. And I know there's some chat questions about, the strength of the evidence, and we got our guy. I want to make sure that's really important, that we have the right person. But, it's true. I think that I'm not going to speak for everybody, but the comment made about, fact specific and then sometimes it's a case by case analysis is really important. I always worry about the mental health part of things, because we've had those individuals who were in court with slugging somebody out at the Walmart. We diverted them. We wanted them to get services. And then they were literally back at, a different big box store where this gentleman punched somebody and fractured the eye socket. So I know we're talking about public safety. One of the things I wanted to say early on when Parissa was doing that great outline is our need to communicate with other departments. I mean, the idea is that when we are talking about individuals who need resources, we need housing, we need to have people with transportation. We've got to do what we can to reach out to other community groups. So this notion of, I do believe, when people are talking about getting rid of cash bail, because it's not about coming to court, because we can fix the coming to court part. It really is about the safety of the community. And we've got to do whatever we can to not only give, our people with their substance use disorders, when people were overdosing in Henrico, the judges were freaking out because they were like, someone's going to die. And so they were holding people because they thought they were actually helping people. And we're like, no.
Question about something you said. Do you think that, and let's focus on the COVID aspect of it, during our current time, anyone should be in either of the two Henrico County jails because they can't afford to pay a secured bond?
Absolutely not. Right. I think everyone agrees with that. That is ridiculous that anybody is being held on a secured bond, because I think we've all taken positions that we're not even asking for that.
And are your assistants saying in court, judge, there's a secured bond that should be converted to an unsecured bond?
Yes, because we are not asking for any secured bonds, period. And actually, our new magistrate that we have has been really good too about doing either personal recognizances or unsecured bonds.
Awesome.
Brian.
Sorry, Ramin, just for time, Parissa, I want to ask you a question about something I know you all did in Arlington. You all, and you mentioned this, were working with the public defender to review some applications for early release or conditional pardons that eventually went to the governor.
I don't know if they've gone to the governor, but we've weighed in.
They went to the governor, I think.
I hope they've gone to the governor.
Been a few months, but whether or not they did, do you think there's room for a Commonwealth attorney, if a defense attorney comes in and makes you a pitch, hey, I'm going to do a conditional pardon application, which for those at home is the governor has the ability to basically take anyone who's serving time in the Department of Corrections and put them out on probation. Say your sentence in DOC is over today, you get to go home. And there's nothing Commonwealth attorneys can do about a case once someone is in the Department of Corrections. So would you, through this pandemic, if someone came to you and said, here's a person I'm going to do a conditional pardon for, will you look at this? Is that something you might write a letter to support an application for a conditional pardon? We've
actually done that, so yes.
Great. And Buddha, have you done that? And if not, is that something you think you might be willing to do?
Have not done it, have not been requested to do it, but would consider it.
And Shannon, what about you?
We had a young person, a request that came to me, but he was going to qualify for the automatic juvenile review. And so I just simply said, look, you're going to be reviewing this young man in 2 weeks. And it was a murder case. that I did not handle because it was from, like I said, 24 years ago. So I simply said, look, we agree with the policies that are in place here, but you're going to be giving the full-fledged review, not just a conditional pardon review. And we deferred, and we want to be deferential to the parole board.
But is that something you'd consider in terms of supporting a conditional pardon request?
Absolutely.
And Ramin, do you think you're not the chief, but is that something you all think you might consider in Norfolk?
I know Greg's mind well. I guarantee you that Greg would consider it and would advocate for it. Now, every day that a person serves beyond what he should serve is unjust.
Great. Buddha, I have a question for you. Everyone here basically mentioned that you have basically in March, and this happened in Fairfax too, where we all got lists for the next 6 months or however long it was, and said, let's look at those people for the next 6 months and say, who can get out? And we're in July now, it's been 3 months, those 6 months are gonna come up soon. Do you think there's room to do another review of, are there people in the jail now whose sentences should be reconsidered to make sure we keep our population down, especially as courts are opening up? Or do you think you've done enough to get your jail population now down that you don't need to worry about that?
I think we have an obligation to our community to have that as a constant review. So I don't think the fact that we handled, let's say, so many individuals back in March and April that we just stopped looking, I think that's a constant review. But I will share something with the viewers as well as the team, that there's a code section that actually allows the sheriff to also consider inmates who are serving a sentence, that they can choose to release them on home electronic monitoring. So sometimes if we hit a speed bump where our court's not willing to be part of that process, then as long as the sheriff believes that it is appropriate, they can do it. They just have to provide notice to the Commonwealth, so that if we have some sort of reaction that we're like, oh my God, this person's not appropriate for that, that we have time to go ahead and object to it. So that is something that should be a constant part of it, COVID or no COVID. We should always be looking at to see if it's appropriate for somebody to be incarcerated.
And Buddha, in Loudoun, do people have to pay for electronic monitoring?
Yes. So what the jail did is, I think it used to be something like a $15 per day fee, but that also included their administrative fees. And then the jail agreed to reduce it, and I'm going to be off maybe a couple of pennies, but agreed to reduce it to the actual cost of the equipment, which is about $5 a day. And we did not have anybody who asked for a waiver, because we talked about what we would do if finances were an issue, because we didn't want to keep somebody in the jail at $166 for a $5 fee. That the math just doesn't make any sense.
Right. And Shannon, you're shaking your head.
We had the exact same issue that came about where if it was home electronic monitoring or the scram bracelet, or pretrial, because our judges are still putting people on certain GPS, and they lost their job. An individual lost their job. We actually, we were able to get the county to help put some money into the jail's budget to help offset that cost, because when you lose your job, it's not like, that's not really a, change. I mean, it is a change of circumstances to revisit in the beneficial way to certain people. But under that circumstance, we didn't want the judge to say, oh, you can't wear the monitor, therefore you have to be in jail. We did not want that. So that was really important moving forward, to have the support of the jail. And then I will also say real quick too, that with COVID, we were trying to make more room for some of the recovery individuals. And we were also talking about the allocation of money, because we had a big task force that talked about this. And we were worried about the money that was going to be allocated being taken away from COVID. And thank goodness the county did not do away with that funding. And so we're still able to work with our recovery community and keeping people out of jail.
And Shannon, is your office willing to keep looking at reconsiderations as we get past that initial set of months for people in the jail?
Absolutely. Brian, I have said since March 16th, and the changes that we've been making, they are not just temporary changes. You know, I think the public, as we see the success on how things are working, are going to have an expectation, and they have every appropriate expectation that this is the new normal. We want to continue doing the good work that we've been doing for the last 90 to 120 days and moving this forward.
And that's a great segue to my next question, actually. And Parissa, I'm going to come to you and then Ramin. Has your sentencing advocacy changed either in misdemeanor court or in circuit court for felonies? And will that continue either through the pandemic or after that? Sorry.
I'm sorry, is this for me first?
Yeah, sorry, Parissa. Yeah.
I'm sorry. I don't think that our sentencing necessarily has changed because we came in with a decarceral sort of perspective. I think that what we can recognize now and can do better, honestly, because we can always do better, is, you know, really we have a dual pandemic, and the dual pandemics are racism and COVID-19. And I am constantly looking for ways for us to do better and for us to advocate for alternatives. And I think we were kind of pretty lucky to get that language in one of the Supreme Court orders where it said that the courts should consider alternatives to incarceration. And I think that really, we didn't feel, we felt like we were, working really hard to keep people out of prison. And I think it gave the judges a sense that they could actually do it too. But I mean, we can definitely do better, and we will keep trying.
Thanks. And Ramin, did it change anything you all were doing in terms of sentencing advocacy? If so, how, and how might that continue or not?
I think it is going to continue. So we had a tradition of considering suspending the remaining balance of a convicted person's crime that has gone back years. We would routinely agree to the suspension of the balance of the jail sentence prior to COVID-19 if someone, for example, completed one of our jail-based substance abuse programs. So that has continued. I think the biggest conceptual change for us is that there's sort of an unsweet spot in terms of criminal sentencing. That's a sentence that is something more than nothing, but is less than a sentence that would send a convicted person to the Department of Corrections and put them in a position to avail themselves of programs there. Really, the worst length of sentence in some ways is between about 9 months and about 1.5 years. And we see a lot of crimes that fall within that range, usually property crimes, some simple possessions. We are only one of the components in the system. And we have Virginia's sentencing guidelines, which is something that the Norfolk Circuit Court judges adhere to at one of the highest rates in the Commonwealth. So I've been emphasizing with my colleagues and with my subordinates that we need to try and do everything we can to avoid these unsweet spot sentences. If a sentencing guidelines recommendation is 1 day to 6 months, we want to look at suspensions on condition of time served. We're not simply going to ask for 30 days because the person did 15 days before. Because first of all, it doesn't seem to have any penological benefit. And second, there's a huge public health risk to doing it, to cycling people in and out of the jail on short sentences. And the same thing for short prison sentences. If there is no alternative, that is what we're going to ask for because that's what's appropriate for public safety or for other considerations. But we very much want home electronic monitoring. We want alternatives to confinement in the jail as a public health measure. And I think that this mindset of, are we really doing either the community or the accused person or convicted person any good with these short prison sentences is something that we are going to carry forward. Sometimes we have no alternatives, but I've been really emphasizing that people should not just mechanically ask for 30 days or 60 days where 1 day with a delayed report and home confinement or work release will do. It just doesn't serve anybody's interest.
Thank you. I want to move on to our second demand, which is that people should be released, but people should be released as quickly as possible. And we've talked a lot about that, but one thing that we haven't talked about yet is the fact that jury trials have been suspended, I would argue indefinitely, in the Commonwealth right now. For everyone, again, at home, Supreme Court says that theoretically might happen in August, but if we have jury trials in August, I will probably be eating my own shoe because I have said that that will probably not happen. So there's a lot of questions there, but we have a lot of people right now where the Supreme Court has also said the speedy trial rights you have by statute in Virginia are told, which means you don't have any, basically from March on. So normally if you're in jail, you have to have a trial within 5 months with a lot of exceptions, but that's not happening right now. So I'm sure in all of your jurisdictions, it's definitely happening in mine. I have people who it's my position are innocent and will succeed at the jury trial, or they'll be sentenced to less than they've served, cannot have what is the default in our system, the basic constitutional principle, which is trial by jury. How has that changed your approach? And what I want to start with is the Commonwealth, the prosecutor in Virginia can ask for a jury if they want, even if the defendant does not want a jury. Are any of you still asking for juries, which means when the defense is not asking for a jury? And Shannon, since you brought up the speedy trial issue at the beginning, I'd like to start with you.
Well, I guess bad timing, because unfortunately I was made aware of a young man in my office who asked for the jury, but that was because he was so annoyed at this court-appointed attorney who is not any of the participants here. I won't say anything more about this individual, but she had not gone to see her client, and we had made this offer. And he said, I said, why are you asking for a jury? Like, this is a judge that, you know, that is going to be very fair. And he said, he goes, Shannon, I'm not going to ask for a jury. He's like, but this so-and-so lawyer has not taken, we've made this offer. She's not taken the offer to her client. I'm getting frustrated. I was trying to protect her. I said, no, you're not going to protect her. You're going to like tell the judge what's going on. You need to communicate with the court if, you know, if something's not being done effectively. And I say that because, Brian, I'll tell you, you've seen the task force, the judges who are there on the task force, who were meeting with Chief Justice Lemons. And I think your Fairfax Circuit Court judge is on there, 2 of my circuit court judges there. And I think what's really interesting is I totally agree with you. I'm worried about the different statutory versus constitutional speedy trial analysis. But I'm also concerned about something else. And I've been participating in a national call about what happens within a state where we let Henrico juries go forward, but we're not letting Arlington juries go forward. And what are we setting up there for an equitable argument there? And I think that's really the next thing that we all need to talk about. And I don't know, and we talked about it in the meeting we just had on Monday when we were talking about jury trials, because I think, you know, when we talk about COVID, we're talking about 3 things. We're talking about infrastructure, we're talking about technology, and we're talking about resources. And so to the extent that Henrico's benefit that we have all 3, but you go to Buchanan County in Southwest Virginia and they have 1 out of the 3, what do we do about that? So I'm not so much concerned about asking for the juries, because my office, other than that one little crazy situation, we should not be asking for them. But the reality is, what is happening? And to your point, to the extent that we have cases where individuals, that there is some type of extreme mitigation, I can tell you as the elected, like a lot of things we've been talking about, I want to know about it. So if there's any frustration about how a case is being handled or asked for a jury, and people aren't satisfied with that, they need to come to the electeds that are here so we can understand what's going on.
Great. And one quick follow-up. Did you have a conversation with your assistant about not putting a jury on something because they're pissed off at the lawyer?
Yes, I
okay.
did.
Thank
I
you.
was like, don't do that again.
Just wanted to clear that up.
Oh yeah, no, we did.
Parissa, what are you all doing in Arlington? Are you asking for juries if the defense is not?
Not right now, no. our philosophy is to never ask for a jury in order to punish a defendant or to raise the stakes. If it's something that we think the community needs to weigh in on, or if it's something that the defense wants a jury for, then we ask for a jury. But we have not, as far as I know, asked for any juries where the defense has not wanted a jury during this time period. And we, have agreed to continuances when the defense, even if they're released and they feel uncomfortable or are at risk. So, we've agreed to continuances for defense and for victims, when they felt that way. And, it is a delicate balance. And I have the same concerns that Shannon does. And they're real in terms of, different jurisdictions behaving differently, because, we are in the DC metro area. And a lot of Virginia is not. So, if the Supreme Court order changes and we still are a hotspot and we still have jurors who don't want to come in, and I just, we had a grand jury this week and they were very unhappy to be there, but we had to have grand jury. Yeah, I mean, that's a very long-winded answer to a yes or no question, but no, we haven't been asking.
Ramin, what about in Norfolk? Are you all asking for juries?
I've been in Norfolk now going on 8 years, and I can't tell you it hasn't happened at all in 8 years, but I can assure you that it's practically never happened. We just don't do that to defendants. We really are morally and philosophically opposed to the jury penalty in Virginia. In fact, we lobbied the General Assembly to do away with jury sentencing.
You yourself are the one down there from a group of several of you on this call doing that. I was sitting across the aisle from you.
I was very proud to be there and represent the jurisdictions who believed in that. And we're really pushing for it, because I think a lot of the sort of equitable concerns that come from our demanding juries come from the fact that juries, frankly, hammer defendants. They are not given complete information about what the alternatives to incarceration are, about what similarly situated defendants get. But no, we are not interested in doing that. I can tell you that nobody on my team has done it. My philosophy is that if there is some reason they think it should be a jury, we'll talk about it. And frankly, nobody's ever come to me about it, because they know that there is no good reason, especially in Norfolk, to do that. So I can't speak for all 40 people. I can't say it has never happened, but I can tell you if it has happened, it's vanishingly rare.
And Buddha, to ask you a slightly different question, how, if at all, is the fact that we can't have juries, for at least a few months, if not for more than that, how is that affecting how you all approach plea offers? How is it affecting how you approach bail decisions?
Let me start with the second part of your question as far as the bail issue. I think everybody's spoken to how we are all trying to make sure that we are looking at the safety of the community, that if that is not a safety risk, then that really should be no issue, right? They should be released. If it's a situation where they're pending trial, that assessment doesn't change. So if somebody is in jail pending trial and we think they're a danger, well, they're not going to be released, right? Just because they're pending trial and there's a jury, there might be a delay. That's not the appropriate calculation there. So we should be releasing everybody who is not a unreasonable safety risk. As far as how we are deciding as to what we're going to do on the front side, as far as with the juries or not, we really have had it a little bit differently here in Loudoun. And I would suggest it this way. We had back in 2019, a fair amount of cases just get continued to 2020 that probably should have been resolved in 2019, but that was maybe strategy. I don't know what the heck it was. But anyway, those are things that were carryovers, that there were decisions made last year. Now, based on this conversation, I just realized that I have a duty and an obligation to my community to go ahead and take a look at each of those cases, because I don't know what decisions were made in regards to the jury. Was it because that was the right decision Or was that a, let me punt it so that we could carry it over, and then now we have that negative impact that we may be incarcerating somebody for a longer period of time. So Brian, thank you, and everyone on this panel for raising that as an issue, because now does this make me realize that I have to go back and look at some things a little bit more intently in that regard.
Great. And I want to move just briefly to our last demand, which is about transparency. And a lot of this, initially when we thought about it, it was for jails and courts and DOC and immigration detention, about how people are getting released, why, what the criteria are, things like that. A lot of that doesn't apply to you all, but you've made a lot of statements tonight about things your offices are doing and are not doing. And a lot of elected prosecutors, it's very difficult to know, people are hesitant to say, we have a policy of X, we have a policy of Y, because facts are so varied. But are there things such as things you've all said tonight? We're going to review cases for reconsideration. And when we do that, we're looking for the following things. We're looking for a release plan. We're looking for programs you did in the jail before COVID. We're looking at whatever it happens to be. Are there things that your offices would commit to putting down in writing or to communicating to the defense bar, whatever it happened to be, to make it clear when we're looking at maybe a conditional pardon letter, a reconsideration, bail determinations, how to make sure we know what your policies are, so that if your assistants are not following those policies, we can go to you or try to get some accountability. I'm going to start with Ramit.
Sorry, took a little while to get the mute. Yes, and I'm going to put this on the agenda of our criminal justice reform working group. I think that especially the area of conditional pardons, like that falls very much in, it falls in the same place as philosophically as conviction integrity units. It's important to remember that 20 or 25 years ago, the philosophy was maximum sentence on most serious charge in practically every instance, and that we have a chance to review on the back end. As far as reconsiderations of sentences and all the rest of it, there's no reason not to put a policy in place. The only concern that I would have is that a written policy might be limited by the limits of our imagination, or that it might suggest that if the policy doesn't, if a request wouldn't fall within the four corners of the policy, that a family or a member of the defense bar automatically wouldn't bring it to us. So I think in some ways, probably the most useful way to say it is to say it as generally as possible. If you have a conditional pardon request, please bring it to us and we'll consider it. If you have a sentence that you believe should be shortened and there's good cause, please bring it to us. We are willing to listen. We are not automatically going to say yes, but we are not automatically going to say no either. And then we can allow the policy almost to grow organically around the nature of the requests that we get.
And I'm going to suggest, and Shannon, I'm going to ask you the same question, that phrases like including but not limited to, factors including but not limited to, and going through those can be very helpful to guide conversations when you're writing those policies. But Shannon, what do you think about written policies or formal policies like that?
Well, Brian, I mean, I do kind of follow the same philosophy that Ramin is saying. And I'll tell you that I am going to be, for this category, I'm going to be more reactionary because, and so the policy would be, if you bring it, I will look at it, we take whatever the other saying goes, that's real kitschy, because as you know, something else I've just taken on is this notion of reviewing body-worn cameras for the behaviors of police officers. And this new position I just put in my office. And so I'm taking, and rightfully so. I don't want anyone to think she's whining and complaining, but rightfully so. I'm trying to figure out where I'm going to be able to expend the energy. And to me, that right now is so critical, but I'm never going to turn down anybody who comes to me. And I know Brad has made a comment about Henrico needs a public defender's office. You're daggone right. And yeah, we were talking about advocating that last year to follow in the steps of Prince William, because really the PD's offices, you all have the best mechanism to have a database of the clients that you've had to say, okay, we know that we can run this program and these individuals were just sentenced in the last, 90 days, 100,
I'm
120
going to tell
days.
you that you are vastly overestimating the case management system of the Indigent Defense Commission. I don't
We'll
think
talk to Dave Johnson about it.
It cannot do anything about that. That's another funding issue later on.
But I guess to the point, I have a lot more faith in the organizational skills of the PD's offices than the solo practitioner who is doing court appointed work, and that young person is just, triaging, right? So I definitely, the policy can be, you bring it, we're going to look at it. And I'd never turn anybody down for that.
And if your policy is going to be that broad, would you commit to reviewing it in a reasonable amount of time? We'll get back to you within 3 weeks. We'll get back to you within 6 weeks, whatever happens.
Oh, sure. Yeah. And we'll try to figure out what that reasonable time period is. I mean, again, Ramin noted that we have a work group that are participants here on this call. and I'm sure we can try to flesh out those details, because I think that we all want to be committed to that. And we'd like to do things, particularly a policy that's important as that. I would love to do the same thing as my colleagues that are here on the panel.
And Buddha, what do you have to say about the kind of the written policy aspect of this?
I too, that with a request such as this, a written policy, I think is just too limiting, and it also ends up becoming something that is it suggesting that there's going to be some contractual rights that if somebody says X, Y, and Z, that it creates those. So I would not lock in my office into that. As Shannon indicated, I actually welcome anybody in my community to reach out to us, because of this reason. They are better situated in knowing what case might be appropriate. And we have that obligation, as well as the privilege, to be able to look at these cases, because the lens has changed. I'm coming across cases, I swear to you, it boggles my mind, where I had an individual back in 2011, there was some screw up with the serving of the sentence. So comes back and hits my desk. They had 3 underage possession of alcohol charges. And over the course of time, the courts imposed 12 months on each one of the suspended sentences. But you're like, underage possession of alcohol, a total of 3 years. Are you kidding me? But these are things that were the norm. So if you've got things like that are misusing our resources, or to an extent, I want to use the word very effectively, abuse of that power that the prosecutor's office or judge undertook, I think it's an obligation that we owe to our community to say, let's just have another eye to it. There might be a reason why this is not appropriate. It may just be equally a reason to say it was appropriate. So I think whoever is in this position has that obligation to have that continuing review, because it's too easy to check the box and say, oh, but we need to have some finality. Yeah, finality is a scapegoat. So I would suggest to you that we do have that obligation to continue to review them.
And do you think you'd at least consider a policy about process, like I talked about with Shannon? If you give it to me, I might be able to get back to you in whatever a reasonable amount of time was, and we will respond.
Yep, as long as you don't lock me into any damn period of time, I'm good.
Not today, but I'm hoping you'll come up with that with whatever works for you.
Yeah, no, all kidding aside, yes, because there should be some expectations. And also, as we know, there's so many challenges in what we do on a daily basis that you don't want to put something on a back burner, because then you haven't really done what you said you're going to do. So, yeah.
And Parissa, I'm going to give you a chance if you want to briefly comment if you have anything else. And the first question I have will go to you from our question and answer period. We'll move
I don't think I have anything to add over what my colleagues have said, and would, also agree to feel concerned about a written policy that goes beyond process for exactly the same reasons that they do, and would look at anything that anybody asked us to look at, and would consider a process type policy.
So questions from people watching. This is a one-word answer question that I want to run through everybody. I'll start with Parissa. But if you had to identify the biggest obstacle to the things you've all talked about in terms of releasing people, showing mercy, trying to get people out of these carceral facilities, what is the biggest obstacle in your system, in your county, in your work to doing that?
Since you didn't pick anybody, I'll go first. Culture.
Okay. Did you say culture? Culture of whom, Buddha?
the culture of the system that we were just talking about earlier, where everybody's real quick to forever paint you as, you know, this individual who needs to be discarded from our community for making bad choices and not having any means to make amends.
So from where the table I normally sit at, there's two people who might have that culture. One is the Commonwealth's attorney, and you're all telling me, you're shaking your head saying that culture is not what you have. Another person who wears a black robe in the courtroom would be the other person who has that culture. So I don't need a verbal yes, but if you shake your head up and down, if that's the person you think is a big problem to enacting these goals.
Brian, think about it. Most of those people in those black robes used to be prosecutors.
Oh, I don't,
So
I'm not think that hard
all
about
you
it.
did is you recycle that attitude.
All right. So to follow up with that, one of you pick this, and this is a hard question, but what can a Commonwealth's attorney do to help re-educate a judge and convince them that they should show mercy to a criminal defendant?
I think Shannon should go first on this. She's been a Commonwealth's attorney on this.
I mean, you know, because Buta, I swear she hit the nail on the head again, which is, you know, when you have judges who've been sitting on the bench for 30 years, and this is not, I'm not advocating that someone who's been only practicing for 5 years has, quote unquote, the skill set to be, you know, a judge necessarily, but it, you know, because criminal justice has changed so much over the last 20, 25, 30 years. And this idea that, you know, we can start educating them. It's kind of like with mental health. Remember mental health? Nobody talked about 15 years ago, but we had to do things like bring in these experts and talk about, you know, cognitive disorders and educate the judges in that way. We can do it this way. And the idea is that particularly when they have two parties, when you do have a prosecutor and a defense attorney saying, Judge, this is the right way of doing things, if we can continue to present them with that information, hopefully in their, you know, 60 plus years of age brain, that old dog can learn a new trick, and we will just continue to advocate for that change.
And are you all training your assistants and telling your assistants to do that type of advocacy in the courtroom?
Oh,
Getting head nods from everybody. So
yeah.
There are really two solutions to the problem that you're talking about. We had a slight disagreement with our judges last year that led to my filing some paperwork in the Virginia Supreme Court.
which led to a horrible opinion from the Virginia Supreme Court.
Very narrow opinion from
Well, and it's beyond the scope of our discussion here, but it's fascinating to read the decision from the Virginia Supreme Court and then to pick up the decision from the DC Circuit that came out in the Flynn case recently.
Right.
But that, again, I don't mean to take us off topic, but one of the ways to educate them is, for want of a better term, courage, is, you know, as a young prosecutor trained in a traditional jurisdiction, I was basically trained to go in and bulldog the judge to get the maximum sentence and not to fold if I ran into resistance from the judge. With age and with perspective, I have learned to bulldog judges, and I've encouraged my assistants to bulldog judges for downward departures from the guidelines where appropriate, for plea agreements where the judges are skeptical. I had a very, very good judge recently, and I took over a case from an assistant. It was one where the defendant was facing, I can't remember if it was 25 or 35 mandatory years on a drug case. There was a legitimate ineffective assistance motion to set aside in that case. I looked at the case, I sat down with the defense lawyer, and I said, I've looked at this case is worth 6 years. We've drafted a plea agreement at sentencing to vacate and take that sentence down to 6 years. And it was a substantial amount of drugs. Otherwise, the sentence would have been lower still. But it was one that was worthy of a serious amount of punishment. It took me 10 minutes to talk that judge through. Why are this being vacated? Is this fair? How does this not open the door to other revisitings? And I finally, at one point, and again, it's one of my favorite judges, I finally had to say, Judge, if you think that it's fair for this defendant to serve 25 years, then sentence him. If you think it is unfair, then take this plea agreement. And that's really a culture thing. You know, we have to back up our assistants just as much when they're asking for a downward departure. And if we get an angry call from a judge, backing the assistants on asking for mercy. Because if the judges see that sort of culture of advocacy both up and down, it both helps educate them and it helps really increase our credibility with the bench to show that we're not advocating, that we're advocating in a considered way. And really, you know, the other solution is a General Assembly solution, but the solution day to day is to encourage our people to advocate and not to fold.
So I want to thank you all for a really great conversation with me. For the end here, we're going to have a few coalition members who are going to come on and ask a similar kind of yes or no question. So keep your answer short, you know, no, ideally yes or no, but no more than 5 or 10 seconds. And that's how we're going to end before we kind of go to a call to action. So Monica, if you could ask your question.
Thank you, Brian. So my question is, do you guys commit to continuing to work to decreasing your jail population by 10%?
By 10%. Yeah, I didn't know about the 10% part, but definitely we're going to keep on working.
And Buddha?
No offense, 10% doesn't seem like it's a high enough number, but yes, go ahead.
Parissa?
I mean, I'm going to commit to continuing to do it. I mean, at 206, I'm not sure how much how much lower we can get, but we're going to keep trying.
I'm sure Brad Haywood would be happy to look at your list and let you know.
Brad and I look at the list together.
And Ramin?
So the short answer is we want to cut everybody out of the jail that we can. Whether we can get to 10%, we'll try. In 2008, our jail had 1,925 people in it. Before our alternative dockets, before our jail treatment, before our criminal justice reform agenda really got going. We're now down to 610. So if we can chop another 61 people off of that number, we'll gladly do it. But please don't hold it against us if we don't get there.
Right. And just, you know, like we can make the commitment to do it, but, you know, we're not the only ones in the courtroom that make the decision. So, and I can tell you, it would have been lower. We would have reduced the population by more than 30% in a month had it been based solely on our office's recommendations.
Thanks, Parissa. Thank you, Monica. Jenny, you have the next question.
Thanks. We all talked a little bit about policies and instituting policies in your office and how you might write those or how vague you wanted to keep them, but can you all commit to disciplining any non-compliant staff members in your office? And I guess I'll start with Parissa.
Non-compliant to what?
Any policies that you set in place in your office.
Yeah.
Especially Buddha.
Rumor has it the rules are different from private practice to the government, so I'm not allowed to take them in the back or the woodshed or whatever the old saying used to be. But actually what we want to do is we want to change the culture, and how we have to do that is recognizing that it is a hard change for them. But with the community sharing what's going on, I think we can educate them, or some people make a decision that they're not going to stay. So I think there'll be some natural attrition.
Shannon.
I mean, I'll just say, yeah, for any policies that I have, and I've actually instituted some policies based on some non-COVID things, absolutely, non-compliance is not negotiable.
So we have one of the really great benefits of practicing in Norfolk is that our policies are designed to be broad by design, so that prosecutors can consider the whole person. The flip side of that is if you violate policy, there's a graduated discipline program from a tongue lashing from your supervisor up to being fired. And yes, because we give our prosecutors more discretion, we absolutely expect them to abide by our policies.
Thanks, Jenny. Brett, I think you have the last question.
So this is a follow-up to something Brian asked earlier about producing written policies for folks, and it sounded like if X, then Y was something that for a variety of reasons wasn't appropriate. But would you commit to putting forth a document that says, among any others, these are the specific type of cases we would like to hear more about? And specifically to Shannon, you had said earlier, you want to hear from people when these type of things are going on, but sometimes the family or the defendant doesn't know that that needs to be heard. So would you commit to putting forth a document that said, these are the type of issues that we want focused on?
Sure, and I am, and specifically, I will continue to work with this group, the Justice Forward group, and the different legal aid center group people. However you want to communicate with me, because again, I do not have a public defender's office. So, to the extent that we can work together on what some of those policies can look like, I welcome our conversation happening.
Buddha?
No, I'm not putting in paper. How about the defense bar do their damn job? There should be no case that they don't consider that if it's appropriate, otherwise that they don't bring before us. Honestly, that is limited thinking. So having said that, I'm sorry?
I don't disagree with you, but having a family be able to put pressure on them to do their jobs correctly, do you think that would be positive?
I think it always is. And look, my biggest thing has been this, where anytime you have an accused or a defendant who's before the court, it really, the family does help and support what the outcome is. Because the more they're within the community and they're made to be a real person, then that also affects the judge's decision. That definitely is going to impact what we do as an office here and how we view them. So without trying to be flip or glib about the in writing, I think in writing what we're doing is we're kind of just not thinking long-term, which is everybody's got that caseload. You know, I did defense work for 25 years. I've got cases in the back of my mind where I'm thinking, oh my God, this would be great for somebody to review. But that's where, you know, my vision is obviously I can't go be digging into those boxes of mine, but that this is something that we as a defense bar have to go back and say, criminal justice is changing. With this new lens, how do we want somebody else to take another look at it? You've got not very many. You have quite a few individuals who are willing to say, I'll come sit at the table with you. Bring it to the table. Worst thing that happens is what? No. What has changed? Not a damn thing. So if we don't give that opportunity for yes, then it's always going to be a no.
Marissa?
I don't know that I have much to add. I think that laying out certain kinds of cases is both over-inclusive and under-inclusive. And, you know, sort of misses like the subtlety of the sort of things that we have to consider. And so I would invite people and defense attorneys to submit for any case. And I will go to the mat with defense attorneys, and I have, and some of them are probably watching, and talk about how I can't do X, but I can do Y, and try to come up with solutions in cases that are appropriate. But, you know, putting it down on paper in that way, I think, you know, I think some defense attorneys will say, well, that's not what they'll consider. And others will say, well, you promised because you wrote it down. And I want to leave it open, and I want to have a dialogue, and I want defense attorneys to come with solutions and ideas and arguments so that we can work together.
Ramin, anything to add?
Yes, and I agree essentially 100% with Shannon, Buda, and Parisa. I would say that the policy, if we wrote it, would be, if somebody is serving a sentence in jail or prison that you think is too long, please contact us. And that's really what the policy should be. And what would really help us a lot more than anything is for all of you all who are lawyers out there, or who have family members who are lawyers, contact your local bar association. Tell them the Virginia Supreme Court is now requiring all lawyers, voluntarily requiring, whatever that means. They're soliciting pro bono hours and pro bono reporting from all lawyers. I would love to see the Norfolk and Portsmouth Bar Association or the Richmond Criminal Bar Association to create a pro bono unit to go and essentially serve as intake. and to bring us these cases. We can't, it's physically impossible for us to ferret out, let's say, every case from 1995 to 2000 to figure out A, who's still in prison, and then B, to start reviewing them. We need people to bring us the cases much more than we need guidelines about what we're looking at. Because right now, I think it's safe to assume that the number in Norfolk that we're reviewing is 0. So we're much more interested in getting the cases. And if the policy has to be, please call us if the sentence is too long, that can be the policy. But I agree, there are really superb criminal defense lawyers, and then there are folks who are not as good. And if we put the policy down, I think we're hurting the people we're trying to help more than we're helping them.
Or if you file more motions to suppress in the beginning, maybe people won't be going to jail. And then I'm just saying that on behalf of a jurisdiction that doesn't have a lot of pretrial work that's happening. And I really want my defense bar to start doing more pretrial work.
Shannon, you're going to regret that when you have a public defender's office.
I'm like, bring it on. That's awesome.
But thank you all. I think you'll all hear a lot more about people contacting you about people and being in prison so long. I'm going to turn it back to Johanna to wrap up.
Yes, I cannot thank you all enough for this absolutely wonderful conversation. We will be sure that it gets spread wide and far. So many lawyers really need to sit through and hear these things. And I really appreciate the really kind of creative and interesting advice that you gave to advocates. Raman, like you said, about contacting local bar associations, about really putting the cases before Commonwealth's attorneys and giving us the kind of language that we can use to write and really get in there with our elected representatives to actually finding solutions to this issue. We have a call to action for our members and other advocates around the state to get in touch with each of their Commonwealth's attorneys. You guys will see I've been live tweeting a bunch from all of the wonderful kind of quotes that we've gotten. So the COVID Justice Coalition will put together from notes and this wonderful conversation some sample language that you guys suggested for advocates to put forward. And we thank you for taking the time to speak with us. This is one of the few times where we have conversations where you can actually feel the hope and understand that, yes, criminal justice reform is changing, and it's about time that our system reflects that. So thank you all, and we will be in touch.
Thank you.
Stay safe and healthy, everybody.